एक सवाल का भी आप जवाब नहीं दे पा रहे हैं, एक डॉक्यूमेंट आपके फाइल में नहीं है।
I'm sorry for that, Your Lordship.
For totally acting contrary to what is expected from a lawyer. देखिए आप क्या है ना, आपको समझाने में मुझे परेशानी हो रही है क्योंकि आपका अनुभव।
I'm sorry, Your Lordship. Then I will file.
For how long you have been practicing?
5 years, Your Lordship.
For 5 years. Do you know how the evidences are laid in a court of law? मेहनत करना पड़ेगा, ऐसे खाली अंग्रेजी बोल देने से वकालत नहीं हो जाएगा। Now please have the book in your hand. CRPC उठाइए सामने से।
जी।
सामने आपकी किताब रखवा दिया है हमने।
मेरे पास।
पढ़िए 293, सेक्शन 293। वकालत करने में बहुत मेहनत है जनाब, ऐसे नहीं होता। Where is the judgment of the divorce case? You are not at all prepared. What kind of lawyer you are? Who is your senior?
I am arguing on behalf of Mr. Sanjay Kumar, Your Lordship.
Where is Mr. Sanjay Kumar?
Yes, Your Lordship.
No, you cannot speak. You cannot speak because you are not trying to understand what the court wants.
Yes, I understood, Your Lordship.
You said many things. कितना कॉस्ट लगा है आपको बताइए? सीनियर को कितना लगा है बोलिए, सीनियर पे करेंगे आपके बदले कॉस्ट।
प्रिंसिपल जज
2009 मैटर।
जी।
How much is the maintenance?
4,000, Your Lordship. And we have placed on record that the wife is living in continuous.
Please read that relevant paragraph from the judgment.
Well, I am very sorry, madam. The file is not available with me, but I have gone through. But
you have started with a good note, but ended very badly.
But I am just here for that. The order is against.
Your senior has sent you just to face the court somehow.
No, actually, Your Lordship, the file has been lost.
So you should have taken the file. I was dictating the judgment.
Yes, I took the file.
You should have taken the file.
And I have gone through the annexures, Your Lordship. Annexure 2 is very relevant, Your Lordship.
This is not the way to argue the matter. You start arguing the matter.
Yes.
Call upon the court to take the books in the hand, and then when the court asks a question to you, you say, I am not having the brief. This is not the way. You cannot go on like this. You started arguing the case. The court thought that yes, you are prepared with the brief and you will argue. You are inviting the court to look into the provisions. And then when one question is asked to you, then you start saying something else.
But I will satisfy you, Lordship.
Show me, do you have a judgment or not?
Right now I don't have a judgment.
I don't appreciate this kind of.
I'm very sorry, Lordship, but the judgment is against the mandate of what?
वही तो आपको कह रहे हैं. You are.
I'm placing that.
You are throwing the propositions.
Yes, Lordship.
So that proposition will be applicable in the facts of this case.
It is applicable for the.
पढ़िए ना, कहाँ है वो? वही तो आपको हम कह रहे हैं बार बार. Abstract principle आप बोल रहे हैं.
जी.
Apply that principle in the facts of your case. Then only you can succeed. Come to the judgment. If you have not gone through, I will take my view after going through it. That is why I ask you whether any permanent alimony has been granted.
As per my instruction, no.
Not granted. So pay under 125. It is only the court says that until permanent alimony is granted.
Yes, sir.
You pay this maintenance.
But the case of the petitioner here is that the wife is continuously living in adultery, Your Lordship. We have made a specific case.
That you could not prove. You could not prove. The court has recorded.
Court has recorded that we cannot decide this matter in this petition, Your Lordship. That
court has recorded that you could not prove the adultery.
No, we have evidence for that. Can you see Annexure 2, Your Lordship, which start from page 22 of the brief, Your Lordship, current brief, Your Lordship. We have annexed the DNA report, which was.
On what ground this divorce has been granted?
On the ground of adultery, Your Lordship.
Where is the judgment?
The judgment is not here.
कैसे होगा? Half-heartedly तो आप सब काम ही half-heartedly कर रहे हैं.
जो एक केवल मेरा सबमिशन सुन लिया जाए. Kindly page 22 देखा जाए जो.
Please Provide me the records.
I will.
I am asking you about your case. You are not giving me. You are every time asking me to please see the provision.
I am not seeing.
Where is the judgment of the divorce case? You are not at all prepared. What kind of lawyer you are?
I am.
You are not at all prepared with your case. Who is your senior? Who is your senior?
I am arguing on behalf of Mr. Sanjay Kumar, Lordship.
Where is Mr. Sanjay Kumar?
He has gone from some personal reason.
Why did not you mention the matter in the morning? If you had any difficulty.
No, actually, he has lost the file. He also has lost the file, Your Lordship. That's
You
why.
do not have anything in your hand. How the court will decide in these circumstances when you are not at all able to render any assistance? एक सवाल का भी आप जवाब नहीं दे पा रहे हैं, एक डॉक्यूमेंट आपके फाइल में नहीं है।
जी हुजूर, एक डॉक्यूमेंट हम आपको दिखाना चाह रहे हैं, काइंडली उसको देख लीजिए हुजूर।
आप मुझे कृपया दिखाइए डिवोर्स केस में जो आपको जजमेंट हुआ है। छोटी सी चीज आपसे हम मांग रहे हैं कि कहाँ है, बिकॉज द कोर्ट सेज द एलिगेशन ऑफ एडल्ट्री अगेंस्ट पिटिशनर इज नॉट प्रूव्ड इन मैट्रिमोनियल डाइवोर्स केस नंबर 97 ऑफ 2010। आप कहते हैं कि डाइवोर्स मिला है एडल्ट्री के
in the divorce case 1997 years, may I make a submission? A report of DNA profiling was called on the petition of the petitioner. He was the petitioner in the divorce case. The report was called. I have annexed the DNA report, Your Lordship, as annexure 2, Your Lordship, which start from.
I have gone through the entire judgment. I am only asking you, how can I come out of this? On the one hand, the court says that adultery could not be proved. You are saying that this decree of divorce has been granted on the ground of adultery. You are arguing something which is contrary to the observation of the court.
But there are facts, my lord. Kindly, these are court documents, Your Lordship. I have annexed from the certified copy of the of divorce case. Kindly see, Your Lordship, and annexure 2, Your Lordship, which start from page 22 to page 24, Your Lordship. On page 24, finding is there of DNA profiling.
देखिए, आप क्या है ना, आपको समझाने में मुझे परेशानी हो रही है।
जब हम
क्यों परेशानी हो रही है? क्योंकि आपका अनुभव।
I'm sorry, Your Lordship. Then I will file.
For how long you have been practicing?
5 years, Your Lordship.
For 5 years. Do you know how the evidences are laid in a court of law? कभी मौका लगा है करने का? नहीं लगा है ना? इसीलिए आप मुझे एनेक्सर पर ले जा रहे हैं। You are not able to understand that this is a revision application, and the court is testing the legality and validity of the or any perversity in the judgment of the learned court below. And the learned court below has dealt with this aspect of the matter. Why the DNA report has not been relied upon? You do not have a copy of the judgment in your hand. How can I refer those paragraphs to you? आप अगर मुझे असिस्ट करना हो आपको, I will have no difficulty, but you must have at least brief in your hand.
I'm sorry for that, Your Lordship.
For totally acting contrary to what is expected from a lawyer. I am ready to assist you, but you do not have a copy of the brief, and you have started arguing the matter. The court has dealt with this aspect. Why DNA report which was placed before the court was not relied upon? दीजिए इनको, पढ़िए जरा। आप मुझे एनेक्सर पढ़ा रहे हैं, रिवीजन में एनेक्सर से केस डिसाइड होगा क्या, बताइए। पढ़िए आप पहले, बोलने में मत रहिए। मेहनत करना पड़ेगा, ऐसे खाली अंग्रेजी बोल देने से वकालत नहीं हो जाएगा। पढ़िए उसको, ऊपर से पढ़िए, जोर से जरा।
He has filed divorce case in the year 2007, and the first time he has taken plea that he is not the biological father of both babies. He has filed photocopies of DNA test, which is marked Exhibit B with objection. It goes to show that the respondent Ashok Sahani is not biological father of both the babies, but senior technical technical examiner Sri R.R. Prasad, who examined the source of both the babies, is not examined in the court. DNA test report was marked on the formal proof. Non-examination of senior technical examiner is fatal for the petitioner. It is well settled principle that the presumption of legitimacy under section 112 of the Evidence Act is conclusive presumption. Presumption cannot be rebutted by DNA test. The conclusive presumption of under section 112 can only be rebutted by the proof of non-access to each other. The report of DNA test is not enough to escape the conclusiveness of section 112 of the Act. If the husband and wife were living during the time of conception, but the DNA test revealed the unrepeatable.
Did you understand why your DNA report has not been relied upon by the court?
Yes, sir.
But you cannot understand it because you have not gone through the case. And you are calling upon the court, please look into Annexure 2, please look into Annexure 3. This is only because you do not understand what has been already dealt by the court. Now, please have the book in your hand. CRPC उठाइए सामने से.
जी.
सामने आपकी किताब रखवा दिया है हमने.
मेरे पास.
पढ़िए 293, सेक्शन 293. वकालत करने में बहुत मेहनत है जनाब, ऐसे नहीं होता है. पढ़िए.
Any document purporting to be a report under the hand of a government scientific expert to whom this section applies upon any matter or thing duly submitted to him for examination or analysis and report in the course of any proceeding under this code may be used as evidence in any inquiry, trial or other proceeding under this code. The court may, if it thinks fit, summon and examine any such expert as to the subject matter of his report. Where any such expert is summoned by a court and he is unable to attend personally, he may, unless the court has expressly directed him to appear personally, depute any responsible officer working with him to attend the court if such officer is conversant with the facts of the case and can satisfactorily depose in court on his behalf.
Therefore, when the DNA report was filed, the author of that DNA report
Must have been examined.
should have been examined,
Right.
and that is what the court has said, that non-examination of that technical person would prove fatal to your case. Now, whether in revisional jurisdiction, this court will look into those documents and upturn the judgment of the court below. Will it be proper on the part of the revisional court?
No, Your Lordship, but if I am.
Therefore, your this submission goes. Now the only thing remains to be looked into is whether divorce has been granted on the ground of adultery.
That I will simply.
Because if the divorce has been granted on the ground of adultery, then of course what you are saying would come to your rescue. Only then subsection 4 of section 125
will apply.
Now there is a finding of the family court that you have failed to prove the adultery. And you are saying that no, I have got divorce on the ground of adultery.
But my lord, I have also made a specific averment that after my marriage, may I speak, Your Lordship?
No, you cannot speak. You cannot speak because you are not trying to understand what the court wants.
Yes, I understood, Your Lordship.
You said many things in the court, in your divorce petition.
Yeah.
But ultimately you could not prove that. That is the finding of the court. Now you are again trying to say the same thing in this court. आप समझिए थोड़ा सा, बोलने से नहीं होता है सिर्फ. जो चीज आपने कहा वहां डाइवोर्स केस में और उसको प्रूव नहीं कर पाए, वही चीज अब आप यहां कहना चाह रहे हैं मेरे पास और हमको कहते हैं कि आप मान लीजिए.
हम डाइवोर्स केस का जजमेंट ला देते हैं ऑन सप्लीमेंट्री ऑर्डर। एक भी
आपको समझा तो रहे हैं इतनी देर से हम।
जी जी।
कितना कॉस्ट लगाया आपको बताइए फॉर वेस्टिंग द टाइम ऑफ द कोर्ट? रिपीटेडली गिविंग यू टू अंडरस्टैंड दैट यू आर नॉट हैविंग इवन द ब्रीफ इन योर हैंड. Why did you start arguing the matter if you were not having the brief?
I'm really sorry, Your Honor, but I thought I will.
From where did you learn it?
But I have gone.
कोर्ट को कुछ भी चकमा देके निकाल लेंगे क्या?
नहीं, जो ऐसा इंटेंशन नहीं था। I thought.
नहीं, इंटेंशन नहीं था। आप इसका मतलब रेगुलर हमारे कोर्ट में आप अपीयर नहीं करते हैं। अगर अपीयर करते रहते तो ये रिस्क आप नहीं लेते। जो रेगुलर अपीयर करते हैं दे नो कि ऐसे नहीं काम चलेगा यहाँ। ये रिस्क आपने क्यों लिया कि बिना ब्रीफ का आपने सोचा कि हम केस पास करके निकल लेंगे? ये पढ़ा करके, वो पढ़ा करके, कुछ बोल करके।
I have gone through the court brief, Your Honor, but
you should have said me at the outset. सीनियर को कितना लगा हुआ है बोलिए? सीनियर पे करेंगे आपके बदले कॉस्ट?
मेरे कलीग
कल आप लेकर के आइए।
एक वीक का टाइम दे दिया जाए।
नो, एक वीक का सवाल नहीं उठता है। कल आप लेकर के आइए।
नहीं हो पा रहा है जो
लिखिए हर्ड